Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hello and welcome to the latest edition of Angeion's Leading Litigator video series. Today it is our distinct pleasure to have Keara Gordon as our guest. Keara is the co-chair of the Class Action Litigation Group at DLA Piper. Thanks for joining us, Keara.
Thank you very much for having me. I'm excited to be here.
As co-chair of the Class Action Group, which I understand includes approximately 100 people, I think your insights are going to be very valuable. I'm intending to break up the interview into sort of a discussion of some substantive law, and then I really want to delve a little bit into your background and into how it is that you manage such a large and diverse group of attorneys across so many offices, and if there's a unique perspective that you bring to it, in part because you're a woman, and so many of these practice groups, and in fact of the most large law firms, are run in large part by men, and I think it's amazing and exciting to hear your perspective on that. So,
great.
With that, let's get into a little bit of the law. So, from the defense side, I would be remiss not to discuss Spokio and how you feel this many months or year, is it a year? I don't even remember exactly, this long later. And I know that you had relied on Spokio in a FACTA case, and I want to talk a little bit about that and talk about whether FACTA cases are dead, in your opinion, in this post-Spokio era. So in whatever order you feel comfortable.
Thank you. So Spokio went a long way in helping to clarify that it was improper for plaintiffs' counsel to bring cases where there's nobody that suffered any actual harm at all. The danger in these kinds of class actions is that you couple the class action mechanism with the statutory damages mechanism, and you have, basically the potential for annihilating damages against companies where really nobody has been hurt in any way, and that seems fundamentally unfair. That used to be attacked by the Ratner Doctrine, but many courts have rejected that, and that's gone to some extent out of favor. So Spokio was a way to say, well, hold on, just because you've alleged a statutory violation, that doesn't mean that you have standing to prosecute those claims if nobody has been hurt. In fact, is a good example of that. You have a circumstance, which we have in one of our cases, which was dismissed by the district court in New Jersey, where an individual went out and bought 3 different articles of clothing at 3 different J. Crew stores, and then took the receipts, put them in his pocket. Nobody ever saw him. Nothing happened to him. Nothing. He wasn't the subject of identity theft. He has suffered absolutely no harm as a result. So the court properly, we think, dismissed that complaint for lack of standing, and that's up in front of the Third Circuit right now. We had oral argument a couple of weeks ago. So we're hopeful that the Third Circuit will follow the Seventh and the Second in finding that there's no standing. The Ninth Circuit just recently decided Bassett, which found no standing in an expiration date case in FACTA. So Noble is still pending in the Ninth Circuit, so there's still the possibility of a circuit split. So that, could be interesting. If there is a circuit split, there could go up, and there could be an opportunity for the Supreme Court to clarify. I think if Noble and Kamal both find no standing, then I think it would be difficult for plaintiffs to continue to file these cases.
So I want to go back to the Ratner Doctrine. I mean, isn't really at the essence of that this is a superiority question?
Absolutely, yes. Yeah, the thought was that the coupling of the statutory damages with the class action mechanism rendered the class action mechanism not superior because it resulted in annihilating damages.
Okay. So let's stick with that theme of superiority, and let's go back to that Ninth Circuit case that I teased before. Hyundai came down. At the time of this filming, the motion for a petition for rehearing en banc is pending. I suspect by the time this is in our viewers' eyes, we will have a decision on that. But I want to talk about sort of the practical aspects of that decision from the defense perspective. Is it really a good decision?
Well, I think it's good and bad. So it's good in the sense for litigating class and opposing class certification or filing a preemptive motion to deny class certification. It gives you two very good things. Number one, the reliance statements are great. Everybody has to have seen the alleged misstatement. That has been clarified. That's good. Secondly, it makes clear about the need to canvass all of the different potential state laws and that is a problem for a litigated class. The problem with the decision, in my mind, is the hurdles that it puts before defendants and plaintiffs in trying to settle class actions. I had always understood that when you're settling a class action, the calculus is different because you are now not analyzing whether the case is manageable for a trial. And that's different than whether you are going to be able to litigate this as a class action at trial. Those manageability issues really encompass things like choice of law and how those choice of law issues are going to play out at trial. Those don't seem to me to really be implicated in the same fashion when you're talking about a settlement class.
No, I think that's right. And, query whether when you're doing sort of your analysis and you're looking at your cost to defend versus your cost to settle, I mean, I'm going to imagine that Hyundai has rather large implications in that analysis.
Absolutely, absolutely, because our clients sadly find themselves faced with meritless, frivolous class actions all the time. And while we fight very hard on the motions to dismiss to get rid of them, and we are often successful, sometimes they get through, and sometimes those cases make it past a motion to dismiss, but they still have no merit. But the amount of money that it costs clients to defend a class action in discovery is really steep. And some people think, oh, that's just the cost of doing business, but that's not right. I've seen so many companies that it really takes a toll on them, having to pay that much money to defend themselves, the time, the distraction of management, having to defend what is at bottom a frivolous case. And then once you've established during discovery to the plaintiffs that there's no there, that the speculation that they had was just wrong, now you're in a box, because how do you get rid of that case with not spending a lot of money because it's not worth it with those kinds of decisions out there?
So it sounds like at the outset it could be very helpful to defendants, in your opinion, because at the motion to dismiss stage it goes a long way. However, if a case gets past motion to dismiss, the global piece that your client is looking for is now gotten more expensive?
I think that's possible. I mean, what I'm hopeful for is that the rigorous analysis that was applied at the settlement stage is applied at the litigated class certification stage. Because if courts are looking that strongly and that rigorously at whether the plaintiffs have met their burden of proving each and every element of Rule 23 by a preponderance of the evidence, then I think it'll be harder for plaintiffs to get a class certified. And that, I think, is a good thing.
I'd like now to turn to more practical law management type issues. Like I said at the introduction, you're the co-chair of one of the class action practice group of one of the largest firms in the country, probably one of the largest class action groups. I've never seen a statistic on that. Can you just tell us a little bit at the outset what challenges are inherent in even communicating amongst that many lawyers?
Sure. I'd be happy to. So we have a very large and very diverse group here at DLA Piper who do class actions. We have more than 100 people who routinely litigate class actions, which is extraordinary. And it's all kinds of class actions, from securities to insurance to consumer to antitrust to privacy and more. So basically anything that our clients are faced with, we can help them. And we also have a tremendous amount of subject matter expertise, white collar, we have government affairs colleagues, so we can pretty much put together a team that can answer any of our clients' needs. Communication amongst our group is essential because with that number of class action practitioners comes tremendous knowledge and tremendous experience. But you have to harness it and you have to communicate with each other. Pretty much any mediator, any judge, any plaintiff's counsel we've seen and we have information about, and it's imperative that we share that information. Pretty much any type of motion that you're thinking of making, we've done. And it's imperative for us to harness that and get the efficiencies from that for our clients. So for example, several years ago, I decided I wanted to file a preemptive motion to deny class certification. It had been recently that Ninth Circuit decision that said, countrywide, that said you could do that. So I thought that would be a really neat trick. And I reached out to our class action practice group, and sure enough, we had folks who had done it. And I got all of their briefs, I got their orders, and it helps you to get a leg up. It cuts down the time in researching and just talking to people who have tried the kind of case that you're about to try, who have done the kind of motion that you're about to do, who've argued in front of that judge. Sharing all that information, I think, really helps give you some additional information. So one of the things that we've done is we have, an email group that routinely talks. So if you need information on a particular mediator or a judge or plaintiff's counsel or a type of pleading, we're constantly communicating.
Or even a claims administrator.
Or a claims administrator, exactly. We do that via email a lot as well. We also have routine conference calls. We have an e-room where we share kind of like a brief bank, and we collect all of our information there. So Spokio, you mentioned. Right. For example, if you're about to file a motion to dismiss based on a Spokio type argument, you can go to the e-room and all of the similar motions that we filed based on Spokio are there, as well as all of the results that we've gotten, as well as a whole bunch of other decisions where we collect that. We also collaborate with each other, and for example, we're getting ready just this week to publish our year-end 2017 class action developments. So that was a collaborative experience. And it's not just in the U.S., however, we are working on putting on a client presentation on global class actions and collective redress, which will take place in Paris, in the UK, and in Germany in connection with our Global Partners conference in June. So in preparation for that, we are having regular calls with our class action and collective redress colleagues in Canada, in the UK, in Germany, in Paris, in Australia, and in other markets as well.
So I didn't intend to ask this at the outset, but personally, I've spoken at or gone to conferences over the last 6 months in Tel Aviv, in London, in Amsterdam, and we're getting just a host of inquiries about sort of this emerging market and playing field that is the international class action. And I'm curious if you see that as a growth area, especially I think a lot of this probably started post-Morrison, right, on the securities side. And I'm curious your opinion, as in your position, what do you think? Are we going to see more of these cases? Are there going to be settlements? What's it going to look like?
Absolutely. I think we are going to see more of them. And one of the things that we as a firm are trying to do is get ahead of that and make sure that we're being coordinated and that we're talking to all of the different jurisdictions. I mean, we've got a number of cases going on right now where we're coordinating with our Canadian colleagues on cases that are pending both in the US and in Canada simultaneously. So it's happening right now, and it's going to happen more and more.
Right. I agree, 100%. So you were talking about some of the aspects that make your particular practice group unique. One of the things that I found unique when I looked into your personal background is you have no dearth of trial experience. And in one in particular, I'm not going to steal your thunder, but it was a pretty long trial, and I was wondering if you could just give us a little bit of background on that and how you think that affects your everyday preparation for your run of the mill cases, if you will.
Absolutely. So I love going to trial. I think trial is really fun. And we had a 61-day trial in New York State Supreme. And there were times where we literally were begging the judge to put an end to the plaintiff's case,
right,
because it was taking so long and the client obviously wanted it to end. But it was really fun, and it was a crazy trial. Everything that could possibly happen during this trial happened. We had witnesses come out of nowhere who hadn't been deposed with documents that had never been seen before. We had all sorts of evidentiary issues. The plaintiff's lost profit expert was on the stand for 13 days. It was crazy. And my closing argument was one of the most fun experiences. My daughter and my mother came to watch.
Now that's pressure.
It was hysterical because my mother and my daughter are sitting next to the general counsel while I'm giving my closing argument. And the greatest part was after I finished my closing argument, from the bench, the judge gave us a complete defense verdict.
Congratulations.
Yeah, it was great. And not only did we get all the claims against our client dismissed, but he granted all of our affirmative claims. Wow. And we got attorney's fees of, I want to say, what did we get, $11 million?
Wow. Yeah. So that goes in the W category.
Absolutely.
Well, congratulations on that one. So Keara, how did that trial win affect your practice?
Well, even before the trial win, I've always been taught, and I think it's correct, that you approach every case like it's going to go to trial. Even though a small percentage of class actions go to trial, early on you devise your strategy, and your strategy remains the same from the beginning to trial, and at each step you try to win. You want to win at the motion to dismiss. You want to win at summary judgment, or if you have to get to trial. But every step you take, you should be taking with the view toward how is this going to augment? How is this going to play to my themes? And how is this going to play at trial?
Let me ask you this. Is it immediately apparent to you if you're litigating at someone who isn't treating a case like they're going to trial?
Absolutely.
I bet that's pretty useful as well.
Absolutely.
So the last thing I want to ask you is what it's like to be a woman in your position. I know from experience, I think everyone kind of does, that this is a fairly male-dominated industry, which is a shame. And you're obviously someone who has risen to prominence in the class action world, and on either side of the V, that's a lot less common. And I was curious if you just talk to our viewers about that.
Sure. I think that nowadays it's a lot more common to have women in the class action bar than when I started 25 years ago. But you get used to being the only person in the room who looks like you. And you can use that as an advantage, I think, in many ways, if you're not intimidated by it. And I'm not intimidated by it. And there have been so many times in my career where people have looked at me and made a judgment about me based on how I look. And if they want to dismiss me and think that they're going to be able to beat me because I'm a woman, if they want to underestimate me, that's fine. Let them, because I will then beat them. And at this point in my career, I've had everything. I mean, we were talking earlier about an example of somebody trying to intimidate me when I was a baby lawyer. I was at a deposition and I had just beaten up the witness the day before. A new lawyer came in the second day, and he literally got up over the table, wagging his finger, sticking his finger in my face, screaming at the top of his lungs, I'm not going to sit here while you learn to ask a question, screaming at me. So I said, please sit down, stop wagging your finger in my face, and stop screaming. I'm not screaming, you're screaming. And this is, of course, before there were videos. So there's nothing to record whose voice is at what level. So I took a break. I went into the partner's office. I gathered myself, and I got a tape recorder. And I went back in, and I turned on the tape recorder, and I said, okay, going forward, this tape recorder will record the level of my voice and the level of your voice and who's screaming. And he stopped. So, you know, I mean, I've had that. I've had every derivation of that. I've been called hun. I've been, you know, so, I mean, basically at this point, there's really nothing you could do to intimidate me. Bring it on. I guess the one thing I would add is that I do think it's really important, though, for us to help mentor women coming up. I think that I love working with women. I've got a lot of women mentors here at the firm who have been fabulous to me, and I really appreciate that. So I do make a very conscious effort to make sure I'm staffing my teams with women. Not exclusively. I'm not going to discriminate against men. Right? But we've got excellent young women class action partners who I think it is our job to mentor and to help them develop, as well as great young associates who, you know, hopefully have more opportunities.
Well, that is truly fantastic. And I've got to tell you, I really enjoyed this interview. I learned a lot, and thank you so much for making the time for us.
Thank you. I really enjoyed it too.